We're known for being a big case firm. We don't go to court with 10 files under our arms, as you will see with many other attorneys. We only take cases where the stakes are very high. We take cases that require extensive preparation. There is a large learning curve for you to go through to get prepared for our meeting. We want you to watch this video before we meet and discuss your case. The meeting will be more meaningful if you do this. Now, I would like to introduce you to the team members. I'm Patrick Clancy. I've been practicing law since 1974. I'm what is called a certified criminal law specialist. In the state of California, an attorney is not allowed to call himself a specialist unless you're certified by the California State Bar. Basically, what that means is I did so many trials, so many appeals, so many writs, obtained recommendations from judges, recommendations from district attorneys, and that then gives you the honor of taking a second bar exam, much harder than the first. The first bar exam had 14 subject matters. The criminal law specialist exam has 1 subject matter. My involvement in cases of false allegations of child abuse and child molestation predates the McMartin case, the infamous case in Los Angeles. Our law firm, as far as I am aware, is the only firm that deals exclusively with issues of false allegations in abuse cases. Dr. Larandos is a major member of our team. He's a psychologist and an expert witness. I met him decades ago on the East Coast when we were both attending training seminars together and giving them together. Over the years, it developed to where he was testifying in my cases as an expert witness. But since he is an expert, a psychologist, and a lawyer, it eventually evolved that we started practicing law together. He's known nationally because of the work that he's published. He published cross-examining experts in the behavioral sciences. And he also published bench book in the behavioral sciences, psychiatry, psychology, and social work. What these 2 books do is train lawyers how to cross-examine experts. It also trains judges. That's what bench book means. In what you look for in terms of scientific reliability with so-called experts who are testifying in the behavioral sciences. Dr. Larandos heads up the science department of our team. He's been fighting junk science's use by the prosecution in abuse cases for decades. His knowledge and research are invaluable to our team and will be invaluable to you. The next person is our investigator. He is probably one of the central figures in our team because I believe the cases are won or lost based upon investigation. Harvey Shapiro was a member of the Riverside Sheriff's Department and was the head of their Crimes Against Persons unit, which is charged with investigating child molestation cases. The training that he has received is enormous. His resume is about 24 pages long. I think he's attended every major seminar ever given, and he's taught at most of these seminars. One of the things that I really like to point out is there is a gentleman named Dr. Stephen Ceci, who is one of the top suggestibility researchers in the world. Stephen Ceci does not like to testify. So what he does is he trains approximately 30 people a year by invitation only at Cornell. Harvey Shapiro was the only investigator that's ever been asked to come and train there. Since then, he's actually given training seminars at Cornell. In 1985, there was only about 1 line in the police training manual. It's called POST, Police Officers Standard of Training, having to do with false allegations. Several years ago, POST came out with a new training manual. Harvey Shapiro was the only defense investigator who was asked to be a consultant on this training manual. He's an expert in suggestibility research and one of the top investigators for the defense anywhere. Besides being a good investigator, he understands people. In representing you, he will use the same tactics that the police use. Let me give you an example. We had a client whose wife had divorced him, moved to Colorado, and every time he wanted visitation, he got accused of another act of molestation. She was living in this rich neighborhood with a very well-to-do doctor and felt that she could just throw lightning bolts down on her ex-husband every time he went for any visitation. One day, she woke up in her nice ritzy house in Denver and found that there was a gentleman named Harvey Shapiro going around door to door to all of her neighbors, finding out about the sex and drug habits of the doctor's new wife, which just happened to be part of the defense. The DA the next day got a phone call from the ex-wife telling the DA that they didn't want to go any further with the case, and the case ended up being dismissed. Harvey knows how to understand people and how to use that to our benefit. Another member of our team is Julie Schumer. Julie is a certified appellate law specialist. Again, the same thing as I said about criminal law specialists. She had to take a second bar examination after handling so many appeals, so many writs, recommendations from judges, and from her peers. Julie is highly unique. If you put Julie in front of a jury, I think she would pass out. She just does not want to be a public speaker in that sense. She's a Phi Beta Kappa English major from UCLA. She's a writer. She's a researcher. Normally, you would never meet someone like her unless you had lost your case and were up before the Supreme Court. However, we wanted to have our motions at the trial level to be of that top quality. They are so good that our motions are now copied throughout the state and are plagiarized all the time. Julie has a lot to do with the building of our motion banks. For those who don't know, motions are documents filed with the court that says that the prosecution has some evidence that should not come in, and here's why. And here's all the law and the cases having to do with that issue. Oh, and by the way, we have some evidence that should come in. Here's the case law and statutes which explain why it should be allowed in. Julie, with her exceptional writing skills, has developed our motion bank. We have probably over 100 motions that have to do with every major evidentiary issue that comes up in a case of this nature. I have several immediate warnings I want to give you that will protect you from what's to come. The first warning is a concept called the pretext phone call. The pretext phone call is when the police have a child or a relative of the child place a phone call to you. The theory behind it is that the police want to get to you while your guard is down and get you to confess to something. While the phone call is being made, it's normal practice for the police to be sitting there feeding questions written down on pieces of paper to the individual who placed the phone call. The concept is okay, and it is legal. However, it is misused. Think about getting a phone call from somebody that says, "You abused me. If you say you're sorry, I won't go to the police." Well, that puts enormous pressure on somebody who's innocent to say, "I'm sorry." In that way, it's over, and they don't have the police involved. However, when those words, quote, "I'm sorry," close quote, are later played back to a jury, it's going to sound like, "I'm guilty." What we recommend is that if you get one of these calls, just say no, nothing happened, and hang up. You do not want to spar with the cops that are on the other end of that phone call. Stay away from it and immediately call us. The second warning is that at any time you're going to be subject to a search and seizure. A warrant may be issued and your house searched, your car searched, and your computer searched. If this should happen, do not interfere with the police officers. You do not want charges of obstructing a police officer to complicate this matter. The third warning has to do with talking to the police. Most people believe that if you don't talk to the police will think you're guilty. Well, it doesn't matter what they think. What matters is the evidence. The police have been trained in a process called the Reed method of interrogation. Now, you haven't heard about that before, but let me tell you this. Back in the 1930s and 40s, the police could beat you with a rubber hose to get a confession. The Reed method of interrogation is a psychological rubber hose. You can be beaten with that psychological rubber hose, and I guarantee you that you'll confess to killing your mother, even if she's still alive. It's that powerful. That is why we tell people, do not be interviewed. Do not be subjected to an interrogation. Ask for an attorney. Assert your rights to remain silent. You should do that whether you're guilty or innocent. What comes out of those interrogations can hurt you even when you're innocent. I want to explain to you what we call the three-ring circus. Sometimes false allegation cases have to be defended in several different areas. That is why we call it the three-ring circus. In addition to defending yourself in criminal court, in some cases, a spouse will begin a divorce case at the same time. Divorces are considered civil and are litigated in the family court. In addition to your criminal defense, the state may file a petition to stop you from having contact with your children. This may be litigated in the juvenile court. Also, if you're a licensed professional, like a physician, a dentist, a nurse, a psychologist, or a therapist, the state may also file against you in the state's licensing administrative court. You can see why we call this the three-ring circus. Sometimes there's even a fourth or even a fifth ring in the circus. And you must remember, in some states, the government may seek to have charges filed against you in a criminal court, the juvenile court, and in licensed administrative courts, all at the same time. In our experience, this teaches us that the prosecutor's office will do just about anything to pressure you to settle for a felony prison term. Obviously, few of us have the funds to fight all of these battles at the same time. That is why these tactics by the prosecution are so effective in compelling the defendant to make some kind of plea bargain to end the suffering. We recommend damage control, or what our emergency room colleagues might call triage. This means that you must pick the battle that is most important and put all of your resources into that fight. We believe that this is always the criminal court. Why? Because you cannot visit your children from a prison cell. You cannot enjoy your marriage from a prison cell. You cannot practice your profession from a prison cell. At the same time, we believe that you must use a defense team that is completely aware of what the standards are in the family law court, the juvenile court, and the state's administrative court, and is able to assist you in those courts also. It is important to make sure that whatever is done in any of these other courts does not hurt your criminal case, and vice versa. This is just another reason why we have experts in our group in the area of family law, juvenile law, and state administrative hearings. Internet stings are the new crime du jour. Let's start with a brief history of the Internet. The concept that led to the development of the Internet can be traced back almost 40 years to academic papers written in the early 1960s on what was called packet switching networks. In 1969, these ideas matured into a working prototype network called ARPANET. Although this network had only 4 nodes or computers connected to it, it was the forerunner of today's Internet. In 1971, 15 universities and research institutes were connected together, and the system was upgraded to handle a seemingly large 64-node network. In 1973, the first European computers were connected in England and Norway. Meanwhile, the key technologies of the Internet, Telnet, FTP, and Unix, were being invented in the early 1970s. Ethernet, invented by Bob Metcalfe, who founded 3Com, would later become the standard for local area networks, or LANs. Telnet allowed remote interactive access to other computers. FTP, or File Transfer Protocol, enabled the transfer of large data files over the network. Unix invented appropriately enough by the phone company Bell Labs and enhanced at UC Berkeley, became the software backbone of the Internet. Later, Sun Microsystems commercialized Unix. The dominant use of the Internet in the 1970s was an early version of email. In 1979, Usenet was invented to carry discussion forums, the primitive form of today's chat rooms. This was the beginning of the more public side of the Internet, as contrasted to the private email and telnet sessions. Usenet would later grow to its present volumes of more than 10,000 separate topic areas and hundreds of thousands of gigabytes of data. That's the equivalent information of large public libraries that is accessed each day. Sexual topics quickly became the single largest volume use of Usenet. Communications and discussion of human sexuality has continued to be an important use of the Internet to this day. Throughout the 1980s and 1990s, the Internet grew exponentially. The number of hosts in 1974 was 1,000. In 1987, 10,000. In 1989, 100,000. In 1992, the number of hosts or computers with permanent IP addresses surpassed the 1 million mark, and it is well beyond that today. This doesn't even count the millions of people who dial into the Internet via modems. In 1993, Mosaic, the precursor to the Netscape browser, took the world by storm and gave birth to what is now known as the World Wide Web. And the rest, as they say, is history. Today, the Internet links more than 170 countries worldwide, with over 1.5 million domain names and over 40 million hosts. Underscoring the new central role of the Internet in American life, and indeed the entire world, a 3-judge federal panel in Philadelphia in June of 1996 called the Internet the most participatory marketplace of mass speech that this country, and indeed the world, has ever seen. However, as popular as the Internet has become, some distorted misconceptions have developed around its use. Because of the Internet's participatory nature and society's interest in sexual topics, the police and the general public have mistakenly begun to look at the Internet as a vast playground for adults who are attempting to sexually prey on children. Well, there can be thousands of actual acts of sexual molestation each day across the nation within family households. The perceived Internet molestation becomes a media circus that ends up terrorizing parents, and yet there is only a few instances by comparison to those molestations that occurred within family households. These alleged Internet predators cause parents to become afraid of nameless, faceless phantoms. More afraid of these phantoms than they are of real, live family members who statistically pose a far, far greater threat to their children. This fear and anxiety becomes even more irrational when it involves homosexuals. Parents look at their children's monitors in the bedroom as a means for a homosexual to kidnap their children and recruit him or her into the homosexual lifestyle. This form of homophobia is at the heart of the parents' fear of the Internet and the hysteria that endangers everyone's constitutional freedoms of free speech. The response of the various police agencies to this fear and hysteria, some of which they have created themselves, is the Internet sting operation. Here's how the Internet sting process got its start. Let's suppose that the police want to create a sting operation to catch a person who fences, buys, or sells stolen property. The police pretend to be burglars who have stolen property to sell. The property is not actually stolen, but the police pretend that it is stolen. The fence buys the allegedly stolen property from the police. In this scenario, it is factually impossible for the offense to buy stolen property from the police, since the property is not stolen. However, even if a person attempts to commit a crime that is factually impossible to commit, he's guilty of the crime of attempt. The offense would therefore be guilty of attempted receipt of stolen property. Now, changing venues. Let's suppose that the police want to create a sting operation to catch a molester, but this time online. The police go to the internet and pretend to be a 13-year-old girl. They advertise in their online profile that they are a minor looking for sex with an adult. Or they enter into chat rooms using this profile and chat with others in the sex chat rooms. As a suspect then engages the police officer who is pretending to be a minor in sexual chat, and eventually a real-life meeting is arranged. The suspect is told to bring lubricants and condoms to the meeting so that they can have a good time. The suspect arrives at a hotel or at a restaurant or at a park as requested by the police officer with condoms and lubricants in his possession. At the hotel, the suspect is arrested for attempted child molestation. It is an attempt because it is factually impossible to commit a child molestation on a 40-year-old police officer pretending to be a 13-year-old. How serious is this? In many states, all attempted crimes carry sentences about 1/2 of the prison term of the named offense. In this case, child molestation, in most cases, lewd act with a minor under the age of 14, carries a severe prison term. In the state of California, it carries 8 years. Therefore, attempted lewd act with a minor under the age of 14 carries a prison term with 4 years. Further, the defendant, if convicted, must register as a sex offender for the rest of his life. Now, let's talk about child pornography. During the same sting chat with the cyber minor, we'll call this person a cyber minor since they're not a real minor, who's really a specially trained police officer, and the internet user, the cyber minor asks that the user, now a suspect, send him pictures of himself. The suspect sends a picture of himself clothed, but this isn't good enough for the cyber minor, so he asks again for special pictures. The suspect sends a nude of himself or of others. The suspect will now be charged with attempted sending of harmful matter to a minor with the intent to arouse, appeal to, or gratify the lust or passions or sexual desires of the adult or of the cyber minor. In most states, a charge like this carries with it numerous years in state prison. Further, each photograph must also be charged as a separate offense, adding years to the sentence. Now consider this. What if the adult and the cyber minor engage in cybersex? Again, the suspect might be charged with sending harmful matter, the conversation, to the minor. The law would not necessarily make an oral conversation harmful matter, but the prosecution's theory is that the electronic transfer becomes material. Now, what if the cyber minor asks the suspect to send him more pictures? This time the pictures depict a minor engaged in sex acts or simulated sex acts. The suspect is now charged with sexual exploitation of a minor. In most states, this offense carries 1 year in the county jail on a first offense and about 3 years in state prison on each subsequent offense. However, if the suspect does not send any child pornography to the cyber minor, that is not the end of the sting. When a suspect is arrested for either attempted child molestation or sending harmful matter to a minor, the police get a search warrant for the suspect's computer. What they find mixed in with adult sexual photographs on the hard drive are several pictures depicting minors engaged in sexual conduct. The suspect is then charged with child pornography or sexual exploitation of a child. We should talk for a moment about how such photos depicting sexual acts between an adult and a minor can innocently get onto a computer. There are numerous ways. For example, what if the suspect received an email with a child pornography picture attached? According to the laws in many states, if the suspect receives unsolicited child pornography over the internet, there is no violation of the law, so long as the suspect does not make copies or send copies to others and destroys it upon finding it. There is no mention in the law that he must destroy these files. However, that is the general case law. However, our attorneys recommend that anyone who receives such unsolicited child pornography immediately destroy it. You don't want to be put in the position of proving that you got it on your drive unsolicited. Now let's talk about cybersex. Cybersex is in fact a masquerade ball, but the police just don't get it or just don't want to get it. You might be surprised how cybersex originated on the internet. Before it was even called the internet, a small group of scientists were connected over a network with their computer. This network was for the exchange of highly scientific and theoretical research ideas. The scientists were mainly men because few women were educated in this scientific field and few had the funds to own a computer. However, there were a few women, and one day an unknown female scientist sent a sexually explicit and provocative email over the internet to the men. She was totally anonymous. The men were shocked by what they had received and thought of it as a misuse of their scientific research network. Even so, they liked it, and they started sending back anonymous responses to the woman. Thus, cybersex was created, a phenomena that was instigated by a woman, not by a man. It is interesting to understand some of the social aspects of this new expression of human sexuality. Throughout time, women have been traditionally taught by society to repress their sexuality. Women had to be both the good girl and eventually the good mother. In other words, they were expected to be virginal before marriage and then faithful during marriage. However, society expected and tacitly sanctioned men to be bad boys, to express their sexuality in a variety of ways. The internet provided women with the freedom to ignore societal restraints on their sexuality and become the bad girl who could satisfy their sexual fantasies through cybersex. There was no social stigma attached because they would remain anonymous. Women also couldn't get pregnant, catch AIDS, or get infected with sexually transmitted diseases. After having a great round of cybersex, she could go and meet with her husband and her boyfriend and be the good girl again, or the good mother, and pick up her children from school. Women had found a safe place to experiment and explore their sexuality without any social stigma attached. Men were not far behind. Those who engaged in cybersex were quick to learn that the ultimate sexual organ is not the penis or the vagina. The ultimate sexual organ is the human mind. With the internet, a 50-year-old mother of 5 could go online and be 16 years old again, engage in cybersex, and lose her virginity on a Friday night. On Saturday, she could lose her virginity again. This may seem simple, but it is 3, 2, 1. This may seem silly, but it is an example of a very popular kind of role-playing in chat rooms on the internet. Likewise, men could pretend to have sex multiple times a night with a variety of women. As for gay men and women, they too found a safe place to meet and enjoy sex without shame or stigma. Few people realize that the internet providers actively pursued gay communities in order to promote their online business through anonymous chat rooms. People experimented with their sexuality over the internet in a number of ways. By role-playing as a heterosexual when they were homosexual, role-playing as a homosexual when they were a heterosexual, role-playing as a man when they were a woman, role-playing as a woman when they were a man, role-playing as a minor when they were adult, and minors sometimes got online and pretended to be adults. It became common knowledge in the internet sex world that cybersex was role-playing, acting out fantasies, and no one knew what was real and what was fantasy about the person that they were chatting with. Eventually, no one believed that the other person online was actually real or that their profile was real. The internet became a masquerade ball in cyberspace. Everyone was protected by a mask of anonymity that hid their true identity. Was that a gorgeous blonde woman you just had cybersex with? Or was it really a man? You would have no way of knowing. Everyone developed a game on the internet primed to unmask the other person in order to find out what was real and what was fantasy. For example, you could request a picture of the other person. However, once they sent you a picture, was it real or was it fake? There was no way of knowing what was real, what was fantasy, without actually meeting face to face. Soon, people started asking to meet. Often, this was done over the phone in order to learn something about the other person. Actual meetings were usually in public places. Sometimes one person would show up and hide and just look to see who the other person was. Can we meet at the mall and look at each other across the atrium? Might be a typical request of this kind of encounter. Now there is a new player in this role-playing game, the police officer. This specially trained police officer is not participating in this fantasy for his own sexual exploration. He has another agenda, and that is setting up an internet sting operation. However, it is important to remember that if the person chatting with the cyber 13-year-old doesn't truly believe that the cyber 13-year-old is actually 13, then there is no attempted child molestation. If the person chatting with the cyber 13-year-old doesn't really believe that the cyber 13-year-old is real, the cyber sex cannot be harmful matter. It also follows that the person talking to the cyber 13-year-old doesn't believe that the cyber 13-year-old is truly a minor. Sending a nude photograph of oneself cannot be charged with sending harmful matter to a minor. Internet sting cases are unique in that almost all of the facts of the case are uncontested. The police make copies of the chats. If a telephone call is made, the police record the phone call. However, our experience is that in all of the cases that our office has seen, the adult on the chat transcript at some place reveals that he does not necessarily believe the profile of the other person. He does not necessarily believe that the other person is truly a 13-year-old minor. In all of the cases that we have seen, the suspect enters into a game of unmasking their cyber partner in order to determine what reality is. In our experience, in the very chat transcripts and audio tapes, we find the defense theory of the case. You see, this is predicated upon the nature of cyberspace, the anonymity that affords one the freedom to explore all fantasies, whether sexual or not. Truly, the logical conclusion is that if a suspect believes in good faith that all that is happening is merely fantasy, he has not committed a crime. Until the police and the criminal justice system realize this, innocent people will continue to be arrested for just having fun on the internet. The Supreme Court still has not outlawed fantasy, but beware of the thought police who do not understand the fundamental principles of cybersex. The myth intensifying parental fears of the internet is that children are being found on the internet and being lured into sexual relationships. The truth is this: if the child isn't looking for sex on the internet, your child will not be found. With over 1.5 million domain names and over 40 million hosts, how do two people find each other over the internet? It's done the same way two people find each other in a city with millions of inhabitants. They go to an area where they share common interests. For instance, if you are a biker and are new in town, you go to a biker show, a biker rally, a biker bar, or a biker sales room to find other bikers. If you're gay and new in town, you might go to a gay bar or go and see a gay band. In all of the cases our office has seen, the minor is a policeman, an adult who goes into an adult sexual chat room. The problem is that in a world built entirely of fantasy, the other person, the victim of the sting, cannot know who is behind the mask. He or she cannot know what is reality and what is cyber reality. Furthermore, the myth that the homosexual will find a child in his or her bedroom via the monitor and will recruit them into a gay lifestyle is a product of hysteria and media hype. Again, to find a person on the internet, a person, adult or minor, must actively go looking for others by going to a common meeting place, like specialized chat rooms. Remember, chat rooms are clearly marked as to what the sexual interests are of the participants. You can't accidentally fall into a gay chat room. And if you do stumble onto a site you don't want to be in, everyone knows that one click of the mouse will lead you to the exit. In cases that we have seen where real minors were involved in gay chat rooms, the minors were in fact homosexual or lesbian, and they were looking for someone that they could talk to or who would understand their concerns. We get numerous telephone calls wanting to know whether or not we recommend taking a police polygraph when the police call and offer you one. We believe that police polygraph examinations are not reliable. We don't need to get into the scientific discussion as to the reliability when an example will suffice. We have had clients that have taken 2 polygraph examinations. Our examiner is the individual who trained police officers throughout his career at the California Department of Justice and later retired. He now does private polygraph examinations. We have had cases where our examiner has passed the person and found them to be not deceptive, while the police department examiner, who is trained by our examiner, found them to be deceptive. Why? We have also seen certain police examiners that never find that anyone passes a polygraph. They always find that the suspect is deceptive. Further, many prosecutors are not moved by a favorable result on a polygraph machine. They only believe the results if they point towards guilty. Why? Well, they have explained it to us that psychopaths have no conscience and therefore demonstrate no stress when they're lying. They believe that a pedophile is a psychopath who can pass a polygraph. If the suspect flunks, they believe the result. If the suspect passes, they don't believe the result. However, nothing is absolute, and on a few occasions we have had cases dismissed upon polygraph examinations. With some lawyers, if the client takes a polygraph and fails it, there is a tendency to stop preparing the case because of the belief that the client is guilty and the case should be plea bargained. At the very least, the attorney does not have the zeal that he or she might otherwise have had. Further, the client may become afraid that the attorney doesn't believe in the case and will not try as hard. There is a breakdown of trust in the attorney-client relationship. With police examinations, too often the polygraph examination becomes a ploy used as part of the interrogation process. This is how they are trained. It is the questioning of the client before, during, and particularly after the polygraph examination that they want. Even if the person passes or it's inconclusive, the officers are allowed to lie. They can tell the suspect that they failed the polygraph examination and then ask the suspect what could have happened that would have caused that. Maybe you accidentally touched her, something to that effect. The polygraph examination is literally used as a psychological ploy to apply pressure to extract some sort of an admission. We would recommend that you not take a police polygraph examination. If you want to have a polygraph examination, you should go to a private, reputable polygraph expert. We have found that many jurors are ignorant about computers and the internet. Also, many individuals that are computer literate and are internet literate have not been in sex chat rooms. To teach these jurors about computers, the internet chat rooms, and the fantasy culture of the internet, we have asked Dr. Harriet to testify in many of our cases. We cannot bring the internet live to the jurors. There are no connections in the courtroom to allow that. So we have developed a video demonstration. Here are actual videos that we used in actual trials to demonstrate these concepts and to provide a defense for our client.
Hi, I'm Dr. James Harriet. I'm a sexual scientist and a computer scientist. I've been working on the internet over 25 years. I have a special interest and expertise in how we communicate sexually and recreationally on this new medium called the internet. I did my PhD dissertation on sexual communication on the internet. And what I'd like to do today for just a few minutes is give you a kind of first-hand glimpse what it feels like to be in this new environment where we do chat and instant messaging on the internet. For those of us who've never used the internet before, let me give you a look at what the tools we'll be using to access or get on the internet. It's a little like television in that we'll be accessing a kind of communication or recreational medium, but it's different from television in that it's an interactive or two-way experience, two-way medium. Not only do I want to understand or hear from the television or the internet, but I want to communicate into or to the other people who are also on the internet. So to do that, we'll be using this screen device. It looks a lot like a television. It's our window into the internet. It's how we find out what other people are saying, what other people are communicating to us. In addition, though, for the other direction of the communication, we have this keyboard. This is how I type my messages, my ideas, my communication into the internet to the other people. And thirdly, I have this pointing device with a little button on it that allows me to point to different buttons or things that look like buttons on this screen, and in just a minute we'll be pressing this sign-on button, which will be how we log on to the internet. Okay, now let's log on to the internet. We're going to log on to AOL. I've chosen a screen name here of Open to More because I am open to more, at least in this session here. And I have to type in my secret password, which I'm doing here, and then using my mouse I'm going to click the sign-on button, and that will actually begin the process of dialing the telephone and logging into AOL, which is our gateway into the internet.
Welcome. You've got mail.
Okay, so now we've successfully logged into the internet. We are actually on American Online, or AOL as it's called, and what you'll notice, we have a welcome screen here, and this is, you can see that AOL really does think of itself in a way as a kind of extension of TVs or movie. They think of themselves as an entertainment medium, showing us movie stars talking about life's guilty pleasures, movies, TV, music, and so on. And we also have a choice of options up here. We can talk to people through instant messaging. We can chat with people. And there's lots of other things, mail and other kinds of administrative settings. But primarily this is a medium, it's not surprisingly, for communicating via chat or email in an entertainment, fun-loving kind of format. Okay, now that we've logged on the internet, let's go meet someone. We have millions of AOL members to choose from, and actually more than that, because every one of those members can have up to 7 screen names, 7 different identities. And each identity can have its own profile, its own description of that imaginary person. So, for example, I can have 7 different versions of me. I can be a man, I can be a woman, I can be a supermodel, I can be all kinds of different things. So let's go meet one of those people and try to have a conversation. To do that, we need to go over to the people part of the AOL screen, and we pull down a menu and go to Member Directory. We click on Member Directory, which allows us to do a search of the member directory, either a quick search or an advanced search, which allows us to specify more details. For example, I could say, well, I really want a female, or I really want someone in the United States, or perhaps I want an occupation, maybe supermodel. Why not? Go for the top. And location, I could pick a city or a state. I'll just say here for short. And then when I've chosen what I want, I hit the search button, and it will search through those millions of screen names, looking for ones which match the profile that I've specified here. Okay, here's the result of the search. Let's see, there's 58 people that match my search. Wow, there sure are a lot of supermodels in my neighborhood. Well, let's look at the names here, see if we recognize anybody. Well, names like Fire Baby, names like Cutie, names like Princess, or here's another one, Superhero, Brit Babe. You know, these certainly aren't the names of people I know in real life, so they must be made-up names. Maybe everything's a little bit made up here. Let's look at one. Let's see, IB Nata, whatever that is. Well, she's looking for a hot, sweet guy. Maybe that's me. Well, let's see. Let's look at it, see if anybody else is around who's actually online. The red mark says we're online. Donna the Babe. Maybe she's the one we want to meet today. Let's look. Okay, well, here's the profile for Donna the Babe. That's the profile that she typed in describing herself. Let's take a look at it. She's female, good sign. She's a super cute supermodel, one of many supermodels, but that's still good. And she says, give her a chance. Well, let's give her a chance. To do that, we hit locate, and sure enough, she's online. She's still online. And what I can do to talk to her is send her what's called an IM, or an instant message. So when I click this, that allows me to send a message directly and instantly to her that she'll get right away. Okay, send an instant message, it says. Now I'm a little nervous. I'm meeting somebody brand new for the first time, a stranger. What do I type? Hi, I think. What's up? I type in internet misspelling mode. Okay, let's see if she responds. We know she's online. It's instant messaging, so she would have received the message in an instant. She has it now. Let's see if she wants to respond or return the favor to us. Sometimes you have to wait, but maybe, just maybe, she'll talk to us. She does. Donna the Babe says, nothing much, just looking for some fun. I think. What kind of fun? Bikini type of fun, I think, provocatively, hoping to move this relationship forward rather quickly. After all, it's more like a movie than real life. Whole lifetimes in movies happen in an hour or two. This kind of relationship can develop very quickly. Wow, she says, in kind of a Valley Girl speak. That sounds so cool. Awesome. I try to match her Valley Girl talk. Cool. By the way, I ask in an abbreviation, a sort of internet abbreviation, what do you look like? I wonder because, of course, I can't see her. I can only see what she types. I really don't know what she looks like. But maybe she'll tell us. Hope so. This is a little bit forward of us to ask about what they look like. But after all, it's just entertainment. It's just fun. Do you think she's going to answer us? After all, she is a supermodel. Whoa. Well, duh, she says, I'm a supermodel. 5'9", great body, long wavy hair. I like, I think to myself, especially the long hair, of course. I think. I wonder perhaps, I wonder if she has a picture of herself. That would be a pretty interesting thing. She wants, of course, to know what we look like. Well, that's easy. We know what we look like. Let's see. Am 24, 6'6". How about dripping wet, just got off my surfboard. I think she'll go along with that. Seems reasonable enough. Meanwhile, should we be thinking about a picture? I think I'll do that. What is she going to say? Well, let's see. This is getting pretty funny, so I'll say laughing out loud, which tells her I'm enjoying this a lot. Oh, she's laughing out loud too. We're both laughing out loud at the same time. Now I know why, yep, she likes bikini fun, because we're going to have some beach fun, at least in our dreams here. Laughing out loud, I'm thinking, let's see, do you have a pic? Where P-I-C, pic, just means picture. I'm hoping, because she's a supermodel, she might actually have a picture of herself that she can send us. She can't send it on instant messaging in this back and forth conversation, but there is an email system we also have, and I'm hoping, just hoping, that she'll be able to send her picture. Oh, can you, she says, sure, just finished a photo session. I say, well, can you send the pic over email? Would love to see it. So if we're lucky, she'll send us the picture. Oh, that was quick. She must have a picture. Well, she's a supermodel. Of course, she's got pictures right at hand. Just a sec, I say. We'll go take a look at my email. So let's do that. Let's take a bit of an intermission from this conversation, and let's go over to the email system, which is over in the upper left corner of our screen, and see if we can go ahead and read the email that she sent. So first I go up to the section called Mail, and then within that I go to a little place called Read Email, Read New and Old and Sent Mail. I click on that button, and sure enough, Donna the Babe has sent me a picture, which is called hotbabe.jpg. JPG means it's a picture file. It's a file of something I can see. I'll hit download here. Download now. I say yes, yes, save, and here it comes. Well, I think she is who she says she is. This is definitely a picture of a supermodel.
File done.
Well, this was my lucky day. I just had a conversation with a real supermodel. And I'm doubly lucky because that entire conversation was recorded by AOL into a file. Let me show you. I go down to the screen here and I press this button, and there you see the entire dialogue that we had, beginning with, "Hi, what's up?" and ending with, "What a great pic, would love to keep talking with you." All of those lines, all of that has been recorded. In addition, I can print it all out for my diary. All I do is go to this icon or picture of a printer, and it says print. I press on this button, and as easy as that, it's already begun printing over on my printer to my right. If you look over here, the printer is now printing out the dialogue that I had with my supermodel friend, Donna the Babe, using our instant messaging facility at AOL. And as easy as that, here is the complete dialogue from beginning to end of everything she said and everything I said. I think this will be great in my diary. Also, earlier I printed out a copy of Donna herself. So we know she's real. There's a picture of her. Or maybe not. Stay tuned.
Hi, I'm Leanna Wolf, and I've been having a great time online as Donna the Babe, the supermodel. One of the things that I was missing was a picture to complement my identity. So what did I do? Well, I went through New Woman Magazine and found this great picture of the woman who I decided to be. I love writing as Donna the Babe, but to look like her, I needed to use this. So let me show you what I do. I have a flatbed scanner over here, and all I need to do is take a picture like this, and it basically allows me to convert it to something I send online. And so it's in the scanner, and I go over to my computer, hit acquire image. My scanner's turning on now. Flatbed scanner is what I'm using, and I simply hit preview. Here's my picture, and I think, okay, well, what part should I send? Let's see. How about that? That pretty much looks like the girl I want to be.
Okay, what we've seen in the last few minutes is that what we see on the internet, what we see with computers, is not necessarily real. Liana has just shown us how she faked her identity as a supermodel by just scanning in a picture from a magazine that she has. What I want to show you in the next minute or so is a different way of faking or changing pictures, making pictures that look real that aren't. It's called morphing. It's a way of changing one picture into another, kind of like using modeling clay to change one thing into another. I'll show you changing Elvis Presley into Barney, and I'll show you changing Cindy Crawford into Claudia Schiffer. Let me show you. Here we go. A picture of Elvis Presley, and I can actually change his picture, change his photograph very slowly, little bit at a time, so he's not really Elvis Presley anymore. He's starting to look like Barney. And there is Barney, and I can change Barney back into Elvis Presley. So what we're learning here is that pictures can be changed from one to the other. Let me give you another case. Cindy Crawford changed into Claudia Schiffer. There is Cindy Crawford. And now I'll slowly change her face so that she's now becoming Claudia Schiffer. And back again. So even supermodels can be changed. Well, this is used a lot in plastic surgery so that plastic surgeons can tell patients what they'll look like after they make changes to them, and can be used to synthesize or change pictures pretty much at will. Pretty much everything we see on the internet and the computers can be synthesized, can be created from nothing. So these last few minutes you've had a chance to look at logging onto the internet, finding somebody else, a complete stranger, using their profiles or descriptions, sending that person an instant message, an instantaneous communication, and finally getting a picture through the email system. This is a very important medium of entertainment and recreation for millions of people in this country and all over the world. So it's very important that we understand this. Thank you. I'm Dr. James Herriot.
I'd like to talk a little bit about the philosophy of our group. In cases such as these, the prosecution has a 98.5% win rate throughout the country. The defense wins at about 1.5%. Now, that's not our win rate. We have a 40 to 60 times higher win rate. Why is that? Well, a public defender handles 350 cases a year. Now, with 220 workdays in a year, you can imagine how much time they spend on an individual case. Now, serious felonies get less than an hour of time from the public defender because of this incredible workload. Now, for private attorneys, they typically handle 80 to 120 cases a year. Why? Because they're trying to pay for those yellow page ads. They take a lot of cases in and they plead as many of them as possible. They get a retainer and then they bargain with you and with the prosecution as quickly as possible so they can move on to their next retainer. You cannot evaluate a case until it is prepared for trial. Let me give you an example. I had a case of a grandfather who was charged with a molestation, and the prosecution thought he was guilty. Our investigator had met a Catholic priest, and he believed that the priest had information about the case, but the priest wasn't talking. Our investigator kept going back over and over and over again. On the fourth day of trial, the priest finally broke and turned over letters that had been written by our client's granddaughter. And in those letters, she said that she had sex with over 40 men in the congregation. Previously, she had been saying that she was a virgin and that the only person that she had been involved with was her grandfather. She was caught lying and making up stories. The charges were dropped on the fourth day of trial. This is the kind of tenacity we bring to continuing litigation. It is also an example of why you cannot evaluate a case until it is completely prepared, until you have all of the answers. This is the kind of tenacity that we bring to continuing litigation. We believe that the preparation must be completed before any decisions can be made about the case. We handle only 8 to 12 cases a year, and perhaps a couple of small cases that we have a special interest in. Our preparation begins on day one. We scan in all the documents, we index all the documents, we capture all audio tapes, we capture all videotapes, and they are put on our computers electronically. We prepare transcripts of all of these tapes. We prepare clips for presentation during trial and during the closing. We have a jobs list where we make a list of everything that we are going to do and the job assignments for every other member of the team that is going to work on the case. We have a chronology that we develop, which we primarily get from you, and we update consistently, telling us absolutely everything that happened in chronological order. We make a witness list while we are receiving these documents so that we can contact every person that is mentioned in any report that may be of any value to us. The reason for this? You can be reading on page 65 and it mentions a janitor who is not involved in the case. And on page 650, you can read about the janitor and now he's become a key witness. How do you go back and find that address that was on page 65? You can't. So we keep track of all addresses as we see them, as we run across them, along with phone numbers and other contact information. We make an outline of every witness's testimony. We do not wait to a week before trial. We begin the very first reading of the case making these outlines. All of these documents, a jobs list, a chronology, a witness list, and outlines for witnesses are all prepared at the same time. We call it multitasking. It's extensive preparation that wins cases. Now, we can teach you everything that we're going to do on your case so that you are an equal partner in the preparation of your case. And we insist that you remain so. Remember, it's your case. Now, the prosecuting attorney will make offers whether or not you want them to. Our job is to make sure that you make an educated and informed decision on whether to accept any of these offers or whether to go to trial. Remember, there is hope. Many clients ask about coverage in their area of California. Simply put, we handle cases all over California. Our team members appear in every California county and have done so for years. We keep connected to our office electronically over the internet through PC Anywhere and other computer programs. It's easy to get around the state of California. With the use of Southwest Airlines and United Airlines, we are linked to all of California. Besides being linked to our own data files and research, our experts, our investigators, and all members of our team are also connected over the internet. This allows our team members to have instant access to all the materials that they need, no matter where they appear in the state of California. Sometimes people will say, well, gee, there's an attorney here locally who says he knows the judge, wink wink. Well, I've never seen a judge or a DA give away the case because of friendship. But what I have seen over and over again is that when we appear in the courts, we're prepared, we have our investigations done, we have our motions done, and we know what we're doing. Within the first day, the judges have gotten to like us because they recognize quality presentations, and that's what they're interested in, and that is what it is. We know that you are located in another state. You need to know if our team can come into your state and represent you. Of course we can. Our team members practice in every state on a case-by-case basis. This is a procedure called pro hac vice. This means that an out-of-state attorney presents his or her credentials to the local trial judge and requests to be allowed to practice just like a local attorney in your area for just your case. In fact, the U.S. Supreme Court has encouraged this practice. Why? So that people can get an expert in the field that they need, because many times these experts are not available locally. When we practice outside of California, we always work with a local attorney. This helps us to make sure that all local rules for your state and your county are followed. We have in our office the law of all 50 states, federal and military, so we are able to represent you in any of these forums. Now that you know the politics and seriousness of the offense that you are accused of, we would like to meet with you. We will try to stop the charges from being filed, if they have not already been filed, by contacting the police and the district attorney. Maybe, if they are presented another side of the case, they won't even file. We will protect the evidence for your defense. This must be done immediately. Before you meet with us, it would be important that you prepare a chronology of events and set out everything that has happened and the time order in which it happened. Clearly mark that attorney-client privilege at the top of the document so that if it is intercepted in any way, it is protected. We also need to know about your background and any prior allegations that have been made against you. You can survive these charges. We believe that the survival is based upon preparation, preparation, preparation. Defending against allegations of this type can be costly. However, you only get one trial. You only get one chance. We cannot guarantee the outcome. Those attorneys who do that are lying to you. What we can do is make sure that everything that can be done will be done. In this way, we maximize your chances of the best outcome in your case. Our investigator. He is probably one of the central figures in our team because I believe the cases are won or lost based upon investigation. Harvey Shapiro was a member of the Riverside Sheriff's Department and was the head of their Crimes Against Persons Unit, which is charged with investigating child molestation cases. The training that he has received is enormous. His resume is about 24 pages long. I think he's attended every major seminar ever given, and he's taught at most of these seminars. One of the things that I really like to point out is there is a gentleman named Dr. Stephen Ceci, who is one of the top suggestibility researchers in the world. Stephen Ceci does not like to testify. So what he does is he trains approximately 30 people a year by invitation only at Cornell. Harvey Shapiro was the only investigator that's ever been asked to come and train there. Since then, he's actually given training seminars at Cornell. In 1985, there was only about one line in the police training manual. It's called POST, Police Officers Standard of Training, having to do with false allegations. Several years ago, POST came out with a new training manual. Harvey Shapiro was the only defense investigator who was asked to be a consultant on this training manual. He's an expert in suggestibility research and one of the top investigators for the defense anywhere. Besides being a good investigator, he understands people. In representing you, he will use the same tactics that the police use. Let me give you an example. We had a client whose wife had divorced him, moved to Colorado, and every time he wanted visitation, he got accused of another act of molestation. She was living in this rich neighborhood with a very well-to-do doctor and felt that she could just throw lightning bolts down on her ex-husband every time he went for any visitation. One day, she woke up in her nice ritzy house in Denver and found that there was a gentleman named Harvey Shapiro going around door to door to all of her neighbors, finding out about the sex and drug habits of the doctor's new wife, which just happened to be part of the defense. The DA the next day got a phone call from the ex-wife telling the DA that they didn't want to go any further with the case, and the case ended up being dismissed. Harvey knows how to understand people and how to use that to our benefit. Another member of our team is Julie Schumer. Julie is a certified appellate law specialist. Again, the same thing as I said about criminal law specialists. She had to take a second bar examination after handling so many appeals, so many writs. Our law firm, as far as I am aware, is the only firm that deals exclusively with issues of false allegations in abuse cases. Dr. Larandos is a major member of our team. He's a psychologist and an expert witness. I met him decades ago on the East Coast when we were both attending training seminars together and giving them together. Over the years, it developed to where he was testifying in my cases as an expert witness. But since he is an expert, a psychologist and a lawyer, it eventually evolved that we started practicing law together. He's known nationally because of the work that he's published. He published cross-examining experts in the behavioral sciences. And he also published bench book in the behavioral sciences, psychiatry, psychology, and social work. What these two books do is train lawyers how to cross-examine experts. It also trains judges. That's what bench book means. In what you look for in terms of scientific reliability with so-called experts who are testifying in the behavioral sciences. Dr. Larandos heads up the science department of our team. He's been fighting junk science's use by the prosecution in abuse cases for decades. His knowledge and research are invaluable to our team and will be invaluable to you. The next person is we're known for being a big case firm. We don't go to court with 10 files under our arms, as you will see with many other attorneys. We only take cases where the stakes are very high. We take cases that require extensive preparation. There is a large learning curve for you to go through to get prepared for our meeting. We want you to watch this video before we meet and discuss your case. The meeting will be more meaningful if you do this. Now, I would like to introduce you to the team members. I'm Patrick Clancy. I've been practicing law since 1974. I'm what is called a certified criminal law specialist. In the state of California, an attorney is not allowed to call himself a specialist unless you're certified by the California State Bar. Basically, what that means is I did so many trials, so many appeals, so many writs, obtained recommendations from judges, recommendations from district attorneys, and that then gives you the honor of taking a second bar exam, much harder than the first. The first bar exam had 14 subject matters. The criminal law specialist exam has 1 subject matter. My involvement in cases of false allegations of child abuse and child molestation predates the McMartin case. the infamous case in Los Angeles, recommendation from judges and from her peers. Julie is highly unique. If you put Julie in front of a jury, I think she would pass out. She just does not want to be a public speaker in that sense. She's a Phi Beta Kappa English major from UCLA. She's a writer. She's a researcher. Normally, you would never meet someone like her unless you had lost your case and were up before the Supreme Court. However, we wanted to have our motions at the trial level to be of that top quality. They are so good that our motions are now copied throughout the state and are plagiarized all the time. Julie has a lot to do with the building of our motion banks. For those who don't know, motions are documents filed with the court that says that the prosecution has some evidence that should not come in, and here's why. And here's all the law and the cases having to do with that issue. Oh, and by the way, we have some evidence that should come in. Here's the case law and statutes which explain why it should be allowed in. Julie, with her exceptional writing skills, has developed our motion bank. We have probably over 100 motions that have to do with every major evidentiary issue that comes up in a case of this nature. I have several immediate warnings I want to give you that will